Okay, we've seen what can happen when people choose not to recognise a state, but what happens when a state doesn't recognise you? Now, you heard me say earlier that the British brought to Australia this thing called common law. This is the idea that laws develop over time through the decisions made by judges on each kind of court case. One of the main ideas that stuck with the British through this legal system is that land is property. Coming from a society that's largely developed over the centuries through various kingdoms fighting each other over farmland, the British got to Australia with a certain mindset on how things should be managed, especially when it came to land. But this mindset was quite different from the Indigenous peoples already here. While Indigenous groups didn't have Christianity or laws all written out in English, they did have established beliefs and customs that varied across the continent. Despite this, none of the British were interested in trying to recognise or understand these long-held traditions. Instead, the Empire, upon settling in Australia in 1788, automatically imposed its own legal system on the continent's Indigenous peoples. Now, as subjects of the British Crown, Indigenous groups should have received equal treatment under English law with all the legal protections it provides. In fact, King George III told Arthur Phillip, the first governor of the New South Wales penal colony, that when he arrived in Australia with the First Fleet, they should endeavour by every possible means to open an intercourse with the natives and to conciliate their affections, and if any of our subjects shall wantonly destroy them or give them unnecessary interruption, it is our will and pleasure that you do cause such offenders to be brought into punishment. In reality, the Empire wasn't too interested in negotiating its plans for continental domination. To realise their plans, the colonisers made the assumption Indigenous groups didn't have any agricultural practices to assert their control over the land, a government to negotiate with, or a large populace that were ready to challenge their conquest. Murder was also considered a rightful action by the British convicts when defending their so-called land rights. So a lot of the time when Indigenous people got in the way, they were killed. There were hundreds of massacres that took place throughout all of Australia from 1780 all the way into the 20th century. Many of these, but not all, have been mapped by a research team up at the University of Newcastle, a project that was started up by historian Professor Lyndall Ryan, which she managed until her death last year. I once had the pleasure of interviewing Professor Ryan for a story I was writing about an alleged massacre of Ngunnawal people that took place aside Lake George, which is about a half hour north of the nation's capital. She told me that mass killings weren't technically legal under British colonial law in Australia, but since the law was so often poorly applied to Indigenous peoples, there was little chance of finding justice for the victims. While colonial governments largely used their police forces to split up Indigenous groups, disperse them to avoid further conflict with European settlers or throw them into jail, Professor Ryan said they could also be culprits in such massacres. In the Waterloo Creek massacre, which took place just outside Moree in regional New South Wales, a mounted police detachment from Sydney is believed to have killed between 40 to 300 Gamilaroi people in defence of British interests. For the alleged incident next to Lake George, Professor Ryan suspected it could have been a mounted police brigade unit from Goulburn who had come upon a group of Ngunnawal people on their way to Queanbeyan. Local elders had passed down the story that after being killed, their people's bodies were thrown into the water. However, Professor Ryan said it was more likely that their remains had been burnt and hidden to erase any evidence of the incident. She said that the telling of these stories would often be altered by Indigenous groups in order to cope with the fact that their people had not undergone the appropriate burial rites that would grant them access to the spirit world. These crimes rarely, if ever, found any kind of justice in the colonial system. However, there was one famous case of the Mile Creek Massacre, which eventually led to some kind of legal recognition for Indigenous peoples. In 1838, a dozen British settlers murdered around 28 unarmed Wuriyai people in northern New South Wales. 11 settlers were initially arrested, but found not guilty by a jury. Then New South Wales Attorney General John Hubert Plunkett and his junior counsel, Roger Terry, were responsible for prosecuting the case. Unfortunately, their only eyewitness to the events was a servant at the Mile Creek station, an Indigenous man named Davey. I say unfortunate because at this time, the law did not allow Indigenous witnesses to provide sworn testimony. The British believed Indigenous Australians could not uphold an oath to tell the truth, as their own spirituality meant that they had no fear of God or understanding of divine judgment for sin. So while they could be put on trial as defendants, they were not allowed to testify on their own behalf, present evidence from other Indigenous individuals, or bring to court their own cases of aggression toward them. Mr. Plunkett didn't take kindly to this idea as a devout Catholic. He believed all peoples were equal in the eyes of God and deserved equal access to the law for protection. After the first trial failed to bring about a conviction, the Attorney General and his aide managed to secure a retrial on a new charge for 7 of the original 11 settlers. And thanks to the evidence of an Indigenous child's rib bone that was found in the ashes of the burnt bodies, the pair managed to find all 7 individuals guilty of their crimes before a judge sentenced them to death at the end of a rope. Following the trial, Mr. Plunkett continued to advocate for the legal recognition of Indigenous peoples. On 3 occasions he attempted to pass a bill that would allow Indigenous people to present evidence in court, which eventually came into effect about 7 years after his death in 1876. This was a small win in a long history of injustice against the Indigenous peoples of Australia. It wasn't until 1967 that they were recognised as human beings, and it took until 1992 for the courts to overturn the idea of terra nullius, correcting the falsehood that they weren't even here at the time of British colonisation. Yet to this day, Aboriginal and Torres Strait Islander peoples are not mentioned in the Constitution. Australia had a crack at changing that about 2 years ago in the 2023 voice referendum, but the people said no.